Hello and welcome to this first of our session of a co-sponsored presentation on behalf of the Australian Association of Financial Advisors. My name is Megan Kavanagh. I'm here with my colleague Cecelia. Hi Cecelia.
Hi Megan.
And we are here today to introduce our firm, Colin Biggers Paisley, and a session that we're going to be offering on a monthly basis for the next 12 months. Over the next 12 months, you'll hear from our colleagues in our privacy banking, corporate, cybersecurity and regulatory teams as we run through some reforms and developments in legal practice, business management and compliance that might be of relevance and interest to you and your client base. It's important to note from the outset that today we're speaking about post-election policy and what that likely means for workplaces and HR practice. The government's only been in place for a couple of months at this point. So we don't have any definitive legislation in place at this stage. So today, Cecelia and I will be speaking about our predictions based on some of the announcements which have been made, some policy directions, some pre-election promises, and announcements which foreshadow the way the direction the government's heading. So when we talk about election reform, the first thing many of us will be thinking about is the Jobs and Skills Summit. This was the enormous grouping of peak bodies and of interest groups in Canberra at the beginning of September in 2022. The major outcomes of the summit, based on its mandate, which was to find opportunities for better collaboration between business and unions, to address some of the pressing issues facing Australian employers, including that of the jobs or skills shortage, the very, very low rate of unemployment, and a real brain drain, I suppose, in the Australian economy post-COVID, where we've lost international students and migration for nearly a 3-year period. The issue on anyone and the pressure on any business, whether that be hospitality, care, education, construction, of not having that influx of immigration is absolutely really limiting the ability of business to grow and to meet demand. And so the purpose of the summit was really to find solutions to those struggles. None of those solutions are quick fix, but what they were focused upon was increasing migration to offset skills shortages and deficits. There's also an increased focus on training. So there will be further funding for universities, but particularly TAFE, for that on-the-job skills training. Another issue which was identified is the casualisation of Australian workplaces is impacting upon bargaining and on wage growth. So there was a big focus from the summit on how the government, unions and employers might reform enterprise bargaining. And there was also a focus on the need or the desire from a lot of Australian workplaces and workers to maintain the flexibilities which have been achieved over COVID. So much of the discussion of the summit focused upon those key areas. We're yet to see any legislation coming out of it, but there have been promises made about increasing the migration target, decreasing the red tape associated with bringing on immigrant workers, changing some of the tests associated with enterprise bargaining, and we'll speak about that a little bit more later on, and talking about how we get more women back into the workplace, how we keep people in work for longer so as to offset some of those skills, real deficits we face at the moment. So ahead of the legislation, where we do, the really firm issues we've got in mind are around migration numbers. I'd be encouraging businesses to have a think about how you recruit. If you don't currently have a practice of looking offshore to meet skills deficits, you might have a think about doing so. You will need some advice about how to manage visa and other restrictions, but that might be, the offshore market might provide you the windfall or the opportunity to increase your skills talent pool, which will help you to meet demand in a much more quickly than finding homegrown talent at this stage. Thanks, Cecelia. Can you tell us about some of the changes we can expect in regards to the operation of the Fair Work Commission?
Thanks, Megan. So during the election campaign, there were certain calls to abolish the Fair Work Commission, but now Employment and Workplace Relations Minister Tony Burke has indicated that that is not the government's intention. Instead, the Labor Party has noted its intention to balance out the appointment of members of the Fair Work Commission to offset what has been described as the stack in favour of liberal-leaning or employer-friendly appointments, after 9 consecutive years of coalition government appointments. Minister Burke has signalled that the balance of appointments will be fixed before a return to what he described as half-half appointments. In simple terms, this means a 50-50 split of appointments from employee and employer backgrounds. Most notably, Justice Ross, President of the Fair Work Commission, retires in January 2024. So his replacement will be a significant new appointment to the Fair Work Commission and might influence future decisions and appeal outcomes. There has been some discussion that the Labor government may reconstitute the Fair Work Commission, including the creation of a new industrial court, which could deal with matters such as wage theft and underpayments, but this remains a case of watch this space. Now moving on to a discussion about increases to minimum wages, which has been a big discussion point pre and post the election. 2021 data shows that wages during that year increased 2.3%, while inflation rose 3.5% in the same period.
So in effect, we're experiencing, or workers are experiencing, a wages decrease where we've got increasing inflation. And when you factor that against the demand for workers, the very historic low rates of unemployment, if employers are sticking to bare minimum award rates of pay, we're going to find it increasingly difficult to get, maintain, keep, incentivise those really important staff, especially where we haven't had those migration numbers come back through yet. So this, for me, is perhaps one of the most important pressures facing employers in Australia today.
Yeah, exactly, Megan. So a bit more discussion on the annual wage review. So the annual wage review sets the net minimum wage and minimum wages under the modern awards. Increases to minimum wage can have a direct effect on all industries and occupations, but those currently receiving the most attention include retail and hospitality, tourism, disability services, early childhood education, and the building and construction industry.
And I think much of this has come from that post-COVID experience where we saw the pressure and the impact of COVID on childcare, on in-home care, disability services, aged care, tertiary and hospital care. Those workers, I think, have now come to the fore in terms of their working conditions and rates of pay. And with many huge exoduses from those industries, coupled with low rates of unemployment, coupled with low rates of migration, we are going to find a real impact on the delivery of services in those sectors if we don't look for immediate change to incentivise and keep people in those sectors. So how are we going to get to that question of immediate change? What can we see coming for us right now, Cecelia?
Yeah, so as I said, mentioned before, the annual wage review obviously became a hot topic during the election, with Mr Albanese advocating for an increase to the net minimum wage that would align with a 5.1 increase in inflation, which was recorded for the March quarter of 2022. In other words, there is a focus on real wages and not going backwards as a consequence of wage growth, being outpaced by inflation and the rising cost of living. Given the last 2 years have seen moderate increases to the national minimum wage and minimum award rates, largely as a result of the pressures of COVID-19, the expert panel made a decision on 15 June to increase the national minimum wage by 5.2% and the minimum award rates by 4.6%.
I have to say, that's actually the largest rate we've seen of increase to the national minimum wage in some years. We haven't had real wages growth in Australia since about 2008 post-GFC. So what we've got from the Albanese government is a real commitment and a real push to increase those wage rates. How that couples with a goal of keeping inflation in check is yet to be seen. There's no real guide or roadmap to balancing those two imperatives.
Yeah, exactly. And finally, on this point, we wanted to raise the proposed inclusion of superannuation in the national employment standards. As you would all be aware, employees currently do not have an express legal right to superannuation in Australia, At present, the superannuation guarantee legislation imposes a penalty on employers who fail to pay the necessary contributions for their employees, but the liability is effectively between the employer and the Australian Taxation Office, meaning it can be often difficult for employees to recover unpaid superannuation. Under the government's plan, the right to superannuation would be included in the National Employment Standards, thereby forming a minimum employment right for all employees. In turn, this will also mean that employees will be able to pursue unpaid superannuation claims for their individual capacity, and the Fair Work Ombudsman will also be involved.
That's a really interesting development, I think, particularly in respect of a topic I'm going to speak about shortly, which relates to wage theft. But before we get to that topic, one of the largest pieces of work coming out of the Workplace Gender Equity Agency in recent times relates to a long-term study about the gender pay gap. That gap in Australia is currently 13.8%, which doesn't place us well against our competitors in the OECD. That 13.8% based on full-time average weekly pay equates to $255 per week. I mean, that can be the difference between making rent or not making rent. And when you think about the precarious nature of women's employment, and particularly that they're working in lots of those industries which are becoming the focus, aged care, community care, childcare, there's a real emphasis then on closing the pay gap as a means of keeping people in those industries. Further, the agency reports that there's a 22.58% difference in the private sector, equating to a difference of $25,800 a year in annual remuneration. So the Labor government's expressed a clear intention to close that gap by empowering the Fair Work Commission to increase rates of pay in low income industries, particularly childcare, aged care and community services. They're going to require companies who engage more than 100 workers to report about gender pay gap initiatives to close those gaps. They're going to prohibit pay secrecy clauses, which is really interesting. Most of the employment contracts we draft will have a provision in it which says employees cannot discuss their pay. This is a big cultural change in Australia if this comes through. What is less clear, though, is how all of this reform, regulation, oversight is going to be paid for. If employers of more than 100 employees are going to be required to report annually on their pay data, this is going to come at a cost. And when employers are already struggling post-COVID, will be struggling with increased wages and the burden of directions from the Fair Work Commission to increase wages in certain industries in particular, it's not clear how this further administrative burden is going to be borne. What is clear, though, is that we are looking at a greater level of regulation around the way that employers engage with their workforces around the question of award or enterprise agreement compliance. In Queensland and Victoria, we've already had wage theft legislation in place for some time. And when we talk about wage theft, we're talking about an intentional failure to pay workers less than their entitlement under an industrial instrument. Now, that question of intent is important. It is going to the idea that employers are deliberately misclassifying workers or underpaying workers. But it might also go to a real negligence in the way that awards and agreements are applied. There is a huge level of non-compliance with awards and agreements in this country, not because of any intention, Cecelia, but because these instruments are highly complicated. They're very difficult to understand classifications and changes in classifications. That stuff is really easy to miss and can give rise to underpayments. What's a concern in this change of legislation is that where employers don't take active steps to manage it, where their management of payroll might be negligent, where they don't have the right resources in place to manage payroll, they may inadvertently step into this wage theft jurisdiction. And interestingly, the national law proposed by the Albanese government will sit alongside the state laws in Victoria and Queensland, but it extends the obligation to meet payroll compliance, not just to your payroll officer or HR, but to boards and those with managerial responsibility. So there's a real personal liability, personal responsibility for not getting this stuff right. And this is the sort of thing that may impact on HR or payroll or boards going forward, because there is an undertaking to publicise these decisions. And where you are found to have engaged in wage theft, employees and unions can claim penalties, back pay and legal costs. So this is the type of jurisdiction that I think employers have to be getting ahead of now, whether that's through conducting privileged payroll audits or at least making sure that you've got the right spend when it comes to payroll compliance. Another significant area of reform, which we've seen done on a state-by-state basis, is the reform to labour hire. Now, in most states in Australia, we have labour hire legislation in place, which provides for a range of entitlements around mostly ensuring that labour hire employees are not treated less favourably or don't have lesser conditions than those who might be employed directly. Most of all, they're going to be looking at things like ensuring portability of leave between industry participants. They're also going to make sure that there isn't an opportunity for some of these phoenixing arrangements or moving employees out of different organisations to try and reduce the entitlements they might otherwise enjoy. So this is going to be, again, another level of regulation that probably will sit alongside that state legislation. So if you're in Queensland, for example, with a labour hire regime in place, you will also have to likely comply with the federal government regime. And it's not clear what that's going to look like or how much duplication is going to be involved. So if you do engage labour hire, or if your clients are engaging labour hire, make sure that they're getting ahead of this and ensuring their own compliance, and that the employees are being categorised and paid as they would be if they were directly employed. Tell us a little bit more then, Cecelia, about what else we can expect, particularly around that initiative which came out of the Jobs and Skills Summit around enterprise bargaining.
Yeah, thank you, Megan. So when it comes to enterprise bargaining, the focus is on maintaining hard-fought terms and conditions of employment and entitlements for employees, and also improving access to bargaining, including via enhanced or improved rights to representation. The key changes that the Labor government has committed to include ensuring that enterprise agreements are bargained for in good faith and genuinely agreed to by a representative cohort of the employees to which they apply. The focus is here on those enterprise agreements which may have been negotiated with only a small handful of staff, with the intention being the employer would then subsequently employ a much larger workforce who would be covered by an agreement in which they have no involvement in negotiating. Another main change is improving access to collective bargaining, including where appropriate through multi-employer collective bargaining instruments. These multi-employer agreements are permitted under the Fair Work Act, but they are not often utilised, and the government's changes are proposed to increase the use of multi-employer agreements in industries which typically have a low take-up rate of enterprise agreements due to the smaller size of employer businesses operating in those industries.
So, for example, we think that the multi-employer agreement, and this has already been said by leaders in childcare and aged care, it's going to be taken up possibly in those industries. Look, it's interesting to see how we're going to change attitudes to enterprise bargaining across Australia, because the rates of bargaining have been dropping drastically over a number of years. And what we've got in place now are lots and lots of old agreements which haven't been renegotiated in a long time. Those are called zombie agreements, and they're fairly in the view of the Fair Work Commission to do something about. Cecelia, what are they going to do?
So another major change that the Labor government has committed to is developing guidelines on good faith conduct in negotiations to allow access to and assistance from the Fair Work Commission to resolve disputes, including giving parties access to arbitration during the bargaining process. Another major change is preventing the unilateral termination of enterprise agreements that reduce workers' entitlements to reverting to modern award coverage. Of particular concern when used as a bargaining tactic for a replacement agreement, or when bargaining for a replacement agreement stalls. Another major change is providing what it calls an effective mechanism for the termination of any remaining work choices agreements.
Bearing in mind that work choices was taken out of play by the Fair Work Act, which is an act of 2009. There are still a couple of thousand work choices agreements in operation in Australian workplaces currently. So that's really, again, something firmly in the view of the Fair Work Commission. Other things that they're looking at in relation to improving the bargaining experience is that review of the Better Off Overall test. Over time, the Better Off Overall test was intended to be a global assessment of agreements based on the idea that you should negotiate an enterprise agreement which leaves an employee better off overall as against the underlying award. However, over time, the application of that Better Off Overall test has been criticised as becoming a line-by-line assessment of how an agreement proposes to be better in every respect than the proposed or underlying award. And what that means is that employers have really been put off bargaining, because the idea of the enterprise agreement is to provide employees with a better off global outcome than under the award, but not a line-by-line outcome improvement. Employers haven't been able to gain these efficiencies or benefits or changes that help them do better in their business or help them to engage with staff in a different way with this Better Off Overall test. Now, interestingly, the Fair Work Commission has responded very strongly to the criticism which has come of their assessment or their application of the Better Off Overall test. At the same time, the Albanese government has said that they really do want to have a different approach or get back to the intention of that Better Off Overall test to make bargaining less complicated. In our experience, anecdotal as it is, lots of employers have walked away from the whole bargaining experience because it's just too hard to meet that Better Off Overall test. Consequently, we have these long-standing zombie agreements, or ones that are well past their nominal expiry date. And for those employees, what they are really receiving are long-held benefits that employers may have negotiated 10 years ago or more, and effectively just award rates of pay. So there is something quite inherently broken currently with the enterprise bargaining system, which the Albanese government, through the Jobs and Skills Summit and through reforms, are trying to address. Again, we're a little light on detail at this stage, but what we do expect to see, firstly, is a greater amount of data coming out of the Fair Work Commission about the negotiation process and about what employers are negotiating on and what rates of pay are being negotiated in those finalised agreements. Now, that's going to be really important for employers, because what they can do with that is feed it into your own forecasting. The other thing we expect to see is a return, as I was foreshadowing before, to a streamlined Better Off Overall test, which will hopefully mean that employers can bargain really meaningful advantages, let's say around the way shifts are rostered or the way that travel allowances might be paid or things of that nature, for increased rates of pay or changes to working hours or those sorts of things. So I hold out great hope for these enterprise bargaining reforms, but it is still a case of watch this space. Another thing that many employers will be really keen to understand more about are the proposed changes to the casual worker engagements and definitions. Now, we have recently seen some changes to those definitions, but the ALP government is proposing to go further, where Workplace Relations Minister Tony Burke recently said there's a direct line between insecure work and low rates of pay. He went on to say that we need to stop replacing permanent jobs with low-paid, insecure, casual jobs where workers have no power to argue for a pay rise. I think that quote there is key to understanding a whole range of reforms we've spoken about today, including the labour hire reforms, the Better Off Overall and enterprise agreement reforms, and this definition of casual worker engagement. The idea, according to the Labor Party, is that because we've got this casualisation of employment, the rise of the gig economy, which Cecelia will speak about, fixed term employment as well, this is affecting ability for people to collectively negotiate to do a better deal for themselves. So what are we likely to see in that respect? Well, first of all, we've already seen cases up before the High Court arguing about what the definition of casual employment is. We think that definition is going to be further reformed to limit casual workers to those most casual of engagements. And that sounds like a bit of a nonsense, I know, but what I mean by that is that for a casual to be a true casual going forward, it's likely that they will have to have a real uncertainty in their ongoing work arrangements. So it won't be a circumstance where an employee works Monday to Friday, 9 till 3, every week, year in, year out. That won't meet the definition of casual worker. They will have to have no expectation of ongoing work and very loose pattern of work around the work that they do to meet that casual definition. So that's one thing we're likely to see. Another thing we already see in relation to casual workers is the right to seek permanency by making an application to your employer. Now, an employer has the right to refuse a request to be made a permanent by a casual employee on a range of factors that they can consider. There's quite a formalised process for getting that right in the Fair Work Act. We expect that that right of refusal is going to be further diminished, that where an employee asks to be, where they can demonstrate a regular pattern of engagement, they may be able to ask to be made permanent. An employer will have fewer reasons to refuse those requests. Again, that draft legislation is yet to be formally introduced, but given the language of the Labor Minister, I think that that's a likely outcome. What has been left hanging, though, is the realisation that for many workers, casual engagement works for them, whether that gives them casual opportunities to work during school time or around caring responsibilities, where it works for them and it works for the employer. It's not clear how those ongoing casual relationships will be able to continue under this new regime, which is really focused on creating permanency in employment. Cecelia, can you tell us more about those initiatives, particularly around fixed term engagement?
Thanks, Megan. So although the Labor government has acknowledged that fixed term contracts have a legitimate purpose in allowing employers to bring in employees for a specific time period to complete a specific project by introducing appropriate skills and expertise, or to manage an expected temporary surge in work, the government is concerned that numerous or consecutive back-to-back fixed term contracts do not provide employees with job security and can be misused so as to avoid ongoing employment entitlements. As a result, the government is proposing to amend the Fair Work Act to limit the number of consecutive fixed-term contracts an employer can offer for the same role, with an overall cap of 24 months, including any contract renewals. The government has indicated that there will be a mechanism for exceptions to the 2-year timeframe in limited circumstances, although to date we do not have visibility as to what those exceptions might be.
And this is going to have a really serious impact, isn't it, on those employers that are dependent upon government funding. So where government funding is not secure in areas like education or healthcare, many employees are on fixed term contracts, and they may be on fixed term contracts for years at a time. So, for example, in education, where funding is uncertain and based entirely on student numbers, there'll be lots of teachers who've been engaged on fixed term year-to-year contracts because a school can't be certain how many kids will be doing physics next year or how many children will be engaged in the tennis program. So for those staff, for those schools, this is going to be a particular challenge, and one which, again, there's no guidance about how that's going to be managed. Similarly, in other organisations where your work might be cyclic or periodic, so for example, in architecture or building and construction, where you've got a finite amount of work for a fixed term project, and you'll want to have people engaged for different areas of different periods of time to meet the demands of that project. But your ongoing requirement is going to be uncertain. This capping of rolling fixed term contracts is going to be prove a real managerial nightmare, and one in which there'll have to be greater investment in HR, there'll have to be greater investment in terms of forecasting workforces, because the idea is if you can only engage someone on 2 fixed-term 12-month contracts to get you to your 24, well, the prospect then is that they've got to become a permanent employee. If that project is a 3-year project, you can't do that for a 3-year fixed term. It's got to be an ongoing engagement. Then you've got the cost of redundancy and consultation and all those sorts of things, which will come at the end of the project, which is foreseen and known. So it's not clear to me yet, and we don't have enough guidance from the government as to how they're going to manage those economic factors, which will flow from ongoing employment. I mean, you'll get yourself into a circumstance where employees will do 3-year projects and then get 6 weeks redundancy pay plus 4 weeks notice every 3 years. And port that along with the long service leave, portability, or other things which are planned to come into play. This is really changing that whole employment industrial landscape and making it much more difficult for employers to engage workers in a way that meets the needs of their business. What else should we talk about in terms of this uncertainty of employment, Cecelia?
Yeah, so another hot topic post the election is the discussion around the gig economy. So currently the Fair Work Commission is limited in its powers to dealing with issues relating to the relationship between employer and employee, whether that be under the Fair Work Act, the various modern awards, or enterprise agreements that have been approved by the Commission. Under the proposed reforms, the Labor government is proposing to extend the Fair Work Commission's powers such that it has a mandate to make orders for minimum standards and terms and conditions for employee-like forms of work, such as for workers in the gig economy, for example, workers that are engaged by the various rideshare platforms and food delivery services. It is anticipated that the practical effect of these changes will be the introduction of industrial instruments, similar to an award that prescribes minimum terms and conditions of engagement for these workers.
Now, this is another really interesting development, and really one that's come to the fore only in the last 5 to 7 years. Whether it's Uber Eats or Uber Transport, the gig economy is something that the industrial environment is really keen to regulate, and for good reason. There's a lot of exploitation of non-English speaking workers, migrants and students. So there is a good reason for it. But I suppose what we're at risk of losing here is some of that flexibility. And again, people who perhaps want to work in that way, who want that level of flexibility or that level of entrepreneurialism. We're yet to see how those factors are going to be balanced, particularly in a post-COVID world where the gig economy has become such an everyday part of our lives. So at this stage, the idea is that these workers will attract all the employment benefits of employees. So that will include leave arrangements and other benefits, overtime, penalty rates and those sorts of things, which in reality is going to make them perhaps represent a huge cost in employing gig workers, or it's going to represent a significant reduction in the gig economy. That's yet to be seen as to how those factors are going to be balanced. One of the other really big drivers over the last couple of years is the idea of respect in work. Now, I don't think there could be too much argument against the idea that everybody at work has the right to be safe. Our work health and safety legislation has been regulating that relationship now for more than 20 years. But the Respect at Work initiative is taking this much further, in particular in relation to questions of harassment and bullying in the workplace. So the Labor government intends to implement all the recommendations coming out of the Respect at Work Sexual Harassment National Inquiry report of 2020. That report found that 37% of people currently in parliamentary workplaces have experienced bullying at work. Safe Work Australia has found similar numbers in other white and blue collar industries. And while there have been attempts, I think, at the workplace level to wipe out issues like hazing or bullying or those sorts of matters, you only have to look at workers' compensation claims to see whether it's an underlying fragility in workers or an effect of working remotely for a long time, we are seeing an increased rise in bullying claims. There's also been an introduction of a whole new jurisdiction in the Fair Work Act for stop bullying orders, where an employee can actually ask the Fair Work Commission to intervene in a workplace to ensure their safety. And what that involves is an employee going to the Commission, making an application, the Commission considering the terms of that application, and then making orders which might range from who is allowed to speak to the employee, who is allowed to direct the employee, where the employee can work, and what work they can be asked to do. So a huge reach into individual Australian workplaces in terms of the way that the coalition government and the Labor government have sought to regulate the instances of bullying in the Australian workplace. So following on from those reforms implemented a couple of years ago, the Respect at Work report recommends key changes be made across the private sector more broadly. And these include creating a positive duty on employers to take reasonable and proportionate measures to eliminate sex discrimination and harassment and victimisation. There's going to be an express prohibition on sex-based harassment in all workplaces in the private sector. There'll be coverage on unpaid workers, I should say, having these same protections. So by that we mean volunteers or work experience, other people who might come into the workplace. There'll be a removal of limitations from the application of these protections. And in addition, the Labor government has promised to introduce 10 days paid family and domestic violence leave in the National Employment Standards. So all of these actions are intended to ensure a better standard of workplace interactions, I suppose really to change the culture of Australian workplaces and to define the types of behaviour which we can no longer accept as reasonable in a workplace. Again, this is going to require a significant impost on individual businesses. You will have to have codes of conduct to comply with these legislative reforms if they come through in the way that's foreshadowed. You'll need to have grievance processes and grievance officers to take those complaints. There'll need to be a collection of data and oversight of the way that these processes are worked. Your boards and management will need to have some level of oversight to ensure that these obligations are being met, or else you'll face not only claims for sexual harassment or stop bullying orders, workers' compensation and things of that matter. It could actually create industrial disputes, inviting the Fair Work Commission to come further into your workplace and look at the way in which you manage this risk. In addition, workplaces already have the possibility of work health and safety in your jurisdiction coming in to investigate complaints they receive of bullying and harassment in the workplace. So what do workers, with all of this reform in mind, what should employers be doing to get ahead of the ball? Well, first of all, I think you should be conducting reviews of your payroll processes. That's absolutely urgent. We suggest that you try to get that done under the veil of legal privilege, and you do that with accountants and lawyers who are specifically skilled in the areas and industries in which you work. As I said earlier, these awards and agreements are highly complicated, and there are law firms and accountants who have specialist expertise in certain agreements and awards. So that's the first thing. The second thing is I think you need to, if you're experiencing a jobs crisis, inability to fill workplace vacancies, have a think about how you might engage with those increased migrant worker numbers. That could provide a really useful opportunity to meet an unmet demand in your workplace. Further, you should be having a look at your contracts of employment to make sure that they don't have provisions which relate to secrecy around wage rates. You're going to need to have a think about how you meet these wage equity requirements. You're going to need to make sure that you have provisions in place in your workplace to address questions of bullying and harassment through your code of conduct, through grievance management, through ensuring you're creating a culture that deals with these issues in a proactive way. And finally, I think if you're engaged with people that are casual or fixed term or gig economy, anyone in that sort of an employment arrangement, you're going to have a real think about how that's sustainable in the future and whether you're going to need to look at a different way of engaging your workers. It's a brave new world that we're looking at in terms of the Albanese government and its reforms. We still are waiting for further detail to be provided, but it's certainly going to be a real challenge moving forward over the next 3 years in the volume of reform. And what we recommend to all of our clients is that this is the time to get prepared and take action now to make sure you stay ahead of the curve. We look forward to seeing you at our next session next month. But in the meantime, thanks for joining us.